Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer, and this is the podcast where we talk all things personal injury law related. And today the question is, what if you were injured by the doing of someone else or a company or something of that nature, and you could not hold them responsible, or your ability to hold them responsible was significantly limited by the law? And what I'm talking about today is tort reform. And if you've never heard of tort reform, it's time you did hear about it, because it's something that is regularly on the agenda of lawmakers, and it affects each and every one of us when new tort reform measures are put into place. So again, what is that? What is that tort reform? First off, tort is the area of law. This is the official area of law that deals with injuries. So a tort, as defined in the law, is something where someone has acted negligently or intentionally to harm someone else. And it's the ability of the person that's injured to make a claim against the negligent party or the wrongdoer. And specifically, tort reform is the legislative efforts to change the civil justice system, especially in limiting damages plaintiffs can receive or altering the litigation process. And so today we're going to dive into tort reform. We're going to talk about what it is, why it matters, and how it's shaping Missouri's legal and business landscape. And Missouri is a key battleground, and it has been at this point for decades, for these types of reforms, with major legislation that has come about over the last couple decades. And there are new efforts underway to put into effect more tort reform measures. So let's break down the history. And we need to start with the very original document that established the United States as a country, the Constitution. And the United States Constitution and then the Missouri Constitution both guarantee the right to a jury trial. And that's important to understand. These are constitutionally given rights to us as citizens. Now, tort reform in Missouri really came into full swing in 2005. At that time, Governor Matt Blunt, by signing laws or bills that had been passed in the Missouri legislature, enacted laws that put into place some significant tort reform measures. It capped non-economic damages in medical malpractice lawsuits at $350,000. So what is that? A non-economic damage, that's the things that don't have a dollar amount specifically attached to them. So for example, a medical bill, that's an economic damage. Lost wages, that's an economic damage. But non-economic damages are all the things a person has gone through, all the harms, all the losses they've experienced because of an injury. And again, that is very often generally referred to as pain and suffering. But of course, it's so much more, because it's the interference that someone has had in their life because of an injury, the things that they could do before the injury that they can no longer do. And it's just the overall life experience of someone after an injury and how it affects them. So that's a non-economic damage. And so in the medical malpractice world, caps were put on. So if someone was going in front of a jury claiming medical malpractice, they were limited to $350,000 of these non-economic damages, no matter what the evidence showed, how catastrophically affected they were in an injury based out of medical malpractice. If a jury awarded them more than $350,000, a judge would then come in and cap that damage compensation to $350,000. Now, another 2005 measure that passed was that it eliminated joint and several liability, meaning that each defendant is only responsible for their percentage of the fault. So prior to 2005, if you had two defendants or more responsible for an injury, if the jury assessed any amount of fault on any one defendant, then a plaintiff could go and try to collect against any of the defendants for the full amount of the verdict. So just to make it an easy example, say a jury compensated an injured person for $10,000. Okay. And let's say there were two defendants. One of those defendants was found 25% responsible for the injury, and the other defendant was found 75% responsible. So before tort reform of 2005, the injured party could go after the defendant that was found 25% responsible for the full amount of the verdict. Okay, for the full amount of what the jury had awarded. But after 2005, it essentially made it so that a person that was injured could only claim against a party the amount that they were responsible for. So, for example, on that $10,000 verdict, the person or the company or whatever that was 25% responsible, the injured person can only go and try to get $2,500 from that 25% defendant. And before, the argument was always, look, the person that's injured, they should be able to get compensated by any body that's responsible. They should be able to get fully compensated, because maybe the 75% defendant doesn't have the assets, the money, whatever, to fully compensate them, but the 25% does. So the law allowed the injured person to go after whomever they could to get the verdict satisfied, the judgment satisfied. But after 2005, the legislature made it so that the person's limited unless any defendant is 51% or more responsible. If they're over 50%, then the injured person can go after that party for the full amount. They also, in 2005, they tightened the rules on venue. And venue is where a lawsuit can be filed, the county it can be filed in. And so before 2005, wherever you could find the negligent party, the wrongdoer, you could sue that person, that company in that county. Okay, so let's just say you have an accident that occurs in Bates County, Missouri. If the defendant resided in either they live there, or if they're a business, they had their business there. Let's say they were in Jackson County or Clay County. You could sue them in Jackson County or Clay County. But after 2005, you can only bring the lawsuit where the accident happened. And then the other big measure that came out in 2005 was the law limited the amount of medical bills an injured person could claim in a personal injury action. So again, before 2005, an injured person could ask the jury to award them the full amount of the medical bills that were charged to them, not taking into consideration what they had paid on the bills, not taking into consideration what insurance, if there was health insurance involved, what health insurance had paid, what was written off, if there was an amount of the medical bills that were written off by the provider, things like that. It didn't matter. It was whatever those medical providers sent a bill to the injured person for, what they charged, that's what could be claimed. But after 2005, it was limited to whatever the amounts were either paid by the person, by health insurance, or what remained outstanding, what was still owed. So those were the big things that occurred in 2005 in the world of tort reform. Now, in 2012, the Missouri Supreme Court took up the issue about the non-economic damage cap or limit in the medical malpractice world. And they ruled, the Missouri Supreme Court in 2012 ruled that the cap on non-economic damages was unconstitutional. And essentially, the court stated that damage caps, they infringed on the jury's constitutional role. And again, if we go back, right, the constitutional right to a jury trial is found in both the United States Constitution and the Missouri Constitution. And so essentially the reasoning was, when you start limiting, when lawmakers start limiting what injured people can claim, they're infringing upon the Constitution and the rights that are given there in those documents. So this decision in 2012 by the Missouri Supreme Court led to a split between those that were advocating for patient protections and those wanting to shield healthcare providers and businesses from large verdicts. And again, you have to think about it that a lot of times the non-economic damages greatly outweigh the economic damages, the medical bills, the lost wages, because again, the most significant impact, an injury, a catastrophic injury, right? A very serious injury, the most significant effect it can have is in that non-economic realm, the living with it for the rest of somebody's life, the daily impact, what they've already gone through, those types of things. And again, juries can hear that evidence of exactly how an injury has affected somebody, and they can award damages for those non-economic damages. So recently, so it's been quiet for a while on the tort reform front, but we have some renewed efforts going on. And in 2023 to 2025, the Missouri legislature has renewed efforts to rein in what some see as lawsuit-friendly climate of Missouri. And there have been bills aimed at reinstating damage caps and tightening venue rules even further. So again, where the lawsuits can be brought. And lawmakers have also explored reforms in asbestos litigation. There's still asbestos litigation going on, product liability, and class action certification. Now, as of today, when I'm recording this, March 31st, 2025, the Missouri General Assembly is actively considering several tort reform measures aimed at modifying the state's civil litigation landscape. So what's on the table currently? First, there's been a Senate bill and a House bill introduced, and both of these are working to align Missouri's class action procedures with federal standards by updating the criteria for certifying class action lawsuits. And again, I know you've heard about class action lawsuits. You probably have potentially been involved somehow in a class action lawsuit when you get the little flyers in the mail and it tells you that you're potentially part of a class for some product that you purchased or some service that you purchased. And what happens is some person brings a lawsuit, and then they seek to find other people similarly situated that have experienced the same problem with the product or the service. And if there's enough people that are brought together, then the lawyers for these people can seek to make this a class action lawsuit so that it's all handled in one lawsuit. So instead of having hundreds, thousands of lawsuits going on, it all gets brought into one in an effort to resolve the claim for all the people that have been affected. And again, as we sit here today, this bill in the Senate successfully passed, again, to bring class action certification in line with the federal standards. And then it's currently under consideration in the House. And again, same thing going on in the House. They're aiming to standardize class action certification in Missouri and align it with the federal procedures. And there's no need for us to dive into what all that looks like specifically, but that's one of the efforts underway in Missouri. Now, another one that is under consideration is a House bill, and it's to change the way settlement demands are made upon defendants or their insurance companies. So again, before a lawsuit is ever filed, there's usually an effort to try to resolve the claim out of court. And that requires a lawyer like me getting all of the relevant, important evidence, information, documentation together, getting it to an insurance company, and making a demand for settlement. And currently, there's a bill in the House that would mandate, again, if it became law, that settlement demands in injury type cases be made in writing. They have to reference the applicable law, and they would have to remain open for 90 days. Right now, we can send a demand letter to an insurance company. We can essentially give them as much or as little time as we want to for them to take consideration of what we've presented to them and make an offer. And if nothing happens, then we can move forward from there. This bill would make it mandatory that we do certain things to comply with the law. We would leave open that demand for 90 days to allow the insurance company to do the work that they do on their end and evaluate the claim and those types of things before we could move forward again with filing a lawsuit. And the other thing that is a biggie, in my opinion, that's underway is another House bill that is proposing to reduce the statute of limitations for personal injury claims from 5 years to 2 years. So right now in Missouri, if you're injured and you have a personal injury claim potentially against someone, or again, a company or whatever it is, you have 5 years from the date of the incident to either settle your claim or get it filed as a lawsuit. Okay, Kansas is 2 years. And the Missouri lawmakers are wanting to bring Missouri alongside Kansas and make it a 2-year time period that it either has to be resolved or filed as a lawsuit. And my opinion on that is that it's not great to reduce that time period because it actually encourages more lawsuits. Because as you might imagine, if somebody is seriously injured and they have to go through lots of medical treatment, lots of rehab, and they've got to figure out what the future looks like for them. 2 years goes by very quickly. And the problem is when you have that situation, if you've got to do something with the claim or it's forever barred. So if you don't settle it or file it as a lawsuit within that time period, it's forever gone. That forces people to go ahead and pull the trigger and file a lawsuit. And again, in my opinion, the 5 years gives people a lot more time to fully get through their treatment, figure out what the future looks like for them, attempt to resolve it with the insurance company outside of a lawsuit, and handle it that way. But again, that is on the agenda right now in the Missouri legislature. Finally, we have another one where they're again trying to deal with evidence of payments in personal injury claims. And House Bill 952 aims to amend how payments for special damages are handled in personal injury cases. Specifically, if a defendant or their insurer pays any part of a plaintiff's special damages before trial. Special damages are like medical bills, lost wages, those types of things. They're also called special damages. That amount cannot be claimed again by the plaintiff from the same defendant, which is an effort to address concerns about potential double recovery. And that one seems pretty straightforward. It seems to make sense, right? If a defendant for some reason has already paid some part of some harm they caused to a person, they're saying they can't then go file a lawsuit and then bring it before a jury to have them compensate them for that amount. So basically, all of these legislative efforts that are underway reflect a concerted push within the Missouri legislature to reform aspects of tort law with the intent to create a more predictable legal environment for businesses and insurers. However, these proposals spark debate, and it's regarding their potential impact on plaintiffs' rights and access to justice. And one of the big concerns that we, the people that represent injured people, always have is, where does it stop? Where does it stop? Because it seems every time there are things put into place in this regard, well, it's just not enough. And then we have to try for more. And again, I talked about in one of my recent episodes, the McDonald's hot coffee case. And you can click up here and you can listen or watch that episode. But it's very interesting to know. What you have to know is there are forces in the business world, in the insurance world, that are always trying to reduce our citizens, consumers' ability to hold people responsible when they do something negligently or intentionally, or they put a product out into the stream of commerce that's dangerous. These business interests, these insurance interests are always working to limit their exposure. And what happens is it limits people that are injured's ability to get fully compensated, to hold people responsible. We always hear about, in these discussions, we always hear about, what about personal responsibility? Shouldn't people take responsibility for their own actions? And my take on that always is, absolutely. Everybody should have responsibility, right? People should be responsible for their actions. And so the ability to hold people responsible should not be limited. And it should remain as it was originally intended, because if we're not holding people responsible, then there's no limits, and it doesn't create a safer environment for us to be out in the world that we know. So it's always a very interesting debate and issue, and it revolves around the narrative that there's too many lawsuits, too many frivolous lawsuits, juries are too easy, out of control, whatever. And another episode that I did was a review of the 2024 jury verdicts in the Kansas City metropolitan area. And it's enlightening to see. And again, I'll put this link to this episode in the show notes, but it was interesting to see that juries are not out of control. And basically less than half the time that somebody is in front of a jury asking for compensation for an injury, something like that, they're getting denied. It was about a 40% success rate for injured people making claims. So 60% of the time, juries were saying no. And then we even broke down dollar amounts, things like that. So it's really interesting to see what reality is, as opposed to the narrative that is pushed by business interests and insurance companies. Insurance companies would love to just keep limiting and limiting and limiting people in what they can claim, how much they can claim, all the things that they have to go through to make a claim, because then insurance companies, they save money, they make more money. So keep that in mind. The Missouri Chamber of Commerce, of course, is one of the big lobbying organizations for the business interest in Missouri. And they always argue that the state is losing business opportunities due to legal uncertainty. And again, if you're looking at the facts, it's just not there. It does not add up. But, this organization will say that tort tourism, meaning that people file lawsuits in Missouri when they're out-of-state plaintiffs. They want to come to Missouri because we're a more liberal state when it comes to personal injury claimants' rights. That's their argument, that we can't have that. But again, the evidence isn't there to bear that out. But the big push now is linking tort reform to economic development, talking about we want to attract manufacturing mega projects, bring into the state big companies, and boosting job creation by making Missouri business friendly and all of these things. This is why we need limits on what people can claim. But critics argue these reforms limit access for genuine victims. And there's concern over how these caps that are put in place on what a jury might render as a verdict for compensation might affect individuals injured by negligence or by malpractice. Again, as I've already touched on, there's two sides to this. And your Missouri Chamber of Commerce, business associations, they're going to say that tort reform reduces frivolous lawsuits, it stabilizes insurance premiums for doctors and hospitals, and it helps attract and retain businesses. And the counterpoint to that is that tort reform protects corporations at the expense of consumers. Again, as you limit what people can do, it frees up what businesses can do. And they talk about damage caps, especially hurt vulnerable plaintiffs like children, the elderly, or those with non-economic damages like emotional distress. And again, a lot of times that stuff is thrown out. Oh, emotional distress. But if you've suffered a catastrophic, serious, life-altering injury, there is absolutely an emotional element that goes with it. I see it all the time. And what's crazy is even sometimes in simpler car accident cases, if you have a 16-year-old person who hasn't been driving long and they get into a serious accident caused by somebody else, that can have a dramatic effect on them. They very well may need counseling and things to work through a newfound fear of being on the roadway, even being in a car, period, not even necessarily as the driver. And again, when you have people that are seriously injured, say someone that's paralyzed because of an injury, that has an emotional toll. Their life is no longer going to be what it once was. And they're going to experience depression, possibly anxiety, and just the uncertainty of not knowing what their future looks like and where money is going to come from so that they can exist, they can continue to live, and they can have the resources they need to live safely now that they no longer can use their body. So there's a real emotional impact there. And that's one of those things that gets thrown out as a, reason for people to think, oh my goodness, look at this, they're claiming emotional damages, but it's a real deal. And again, I see it all the time. And basically, opponents of tort reform say juries, not lawmakers, should determine what's fair compensation. And let's think about this a minute. So who are these juries? These juries that get disparaged, these juries that we're told are out of control, that give away money just without really any thought about it. Juries are made up of you and me. So when you get that jury duty notice in the mail, you could become a juror, right? And you're the one, if you're on a jury, you're the one listening to the evidence in a specific case. And the jury is the one that's tasked with looking at the person making the claim, looking at the person that allegedly caused the harm, looking at the credibility of these people, looking at the evidence of the severity of the injury, looking at everything that goes into that case and making a decision. And essentially, because of these arguments that come from business interests and insurance companies, lawmakers then, because again, there's a heavy influence on lawmakers from business interests and insurance interests, but now the thinking is lawmakers know better than you and I know when it comes to specific cases. And again, there absolutely can be rules and procedures, and there are lots of rules and procedures that surround lawsuits and how they can proceed and what can be claimed, things like that. But when it comes to the critical components of a specific case, the damages that are at issue, who's responsible, the people that are in the best position are the 12 people that are tasked with listening to the evidence in that case. And that's it. They are the boots on the ground in that instance. There's been, of course, studies that come out with regards to tort reform. And there was one by the University of Richmond Law School, which basically showed that these caps that are put into place rarely reduce insurance costs and often shift the burden to the victims, the injured people. And shockingly, as you might imagine, it doesn't always go hand in hand that certain things are put in place and insurance companies decide we don't have to charge as much now. It's interesting to note that Missouri has been ranked as a judicial hellhole by the American Tort Reform Association now for several years. But again, I would encourage you to listen to my episode where I actually break down what juries actually did in 2024. And you can just see by the actual statistics that at least here in the Kansas City metropolitan area, which you really have to look at that area in St. Louis to get a real handle, because we have the most jury trials going on in a given year. You have to look at those statistics to realize that Missouri is not a judicial hellhole. So I would encourage you, if you're listening to this, to tune in to what the legislature is attempting to do. And if you have a connection to a lawmaker, I would highly encourage you to reach out, because here's the thing. This is one of those areas that not a lot of people pay attention to until something happens to them. And again, I spend every day talking to people who are injured, and I have to tell them what can and cannot be claimed based on what lawmakers have done. So I see it, and I see the real world impact of these reforms that come into place. And just like the medical bills, again, after 2005, it changed what someone could claim as far as medical bills. The reasoning was always that why should the person that hurt somebody get the benefit of the injured person's health insurance or things of that nature? They should be on the hook for the medical bills that were charged. If a doctor comes in and says, this is the reasonable charge for this treatment, then that should be what is claimed. And that wrongdoer shouldn't get the benefit of what the injured person has paid for, health insurance benefits. They've been paying for that. And so that was an argument. But again, it was unsuccessful. And the medical bill reform went into place, and it has dramatically affected the value of some people's claims that they have for injuries, because instead of dealing with the top dollar charge that the doctor sent them, it could be dealing with a lot less based on what was written off by insurance companies, what was actually paid, things like that. The state's legal system, it continues to evolve. This tort reform in Missouri, it's a high stakes balancing act between fairness, access to justice, and economic development. And of course, I understand we need business development in Missouri, but the question has to be at what expense? At the individual expense, or should companies be made to hold to a standard that provides a safe operating atmosphere in our state? And again, as the state's legal system continues to evolve, and how it does will affect all Missourians. There's no question about it. And again, it's not a big topic, not necessarily something you're going to read about on the front page of any news outlets, but it's there and it's always at issue. And so whether you're a business owner, you're a patient, or you're just someone who wants a fair shake if you're injured, this issue does touch your life, and you should know what's going on. So again, I encourage you to keep on top of it, know what's going on out there, reach out to your lawmaker, let them know your opinions on this, because if you don't, they're only going to be hearing from the bigger interests that, based on dollars and cents, are going to make sure they let these lawmakers know how they feel. So I hope you found this episode useful and informational as always. And please continue to follow, and until next time, be safe and be well.